Hey everybody, it's midnight in the shanty. Well, it's not really midnight, but it's 9:30 on Tuesday. What are we doing in the shanty at 9:30 on Tuesday? Well, we're enjoying a scotch and a cigar and sitting by the fire. See the fire there? There's a fire. Okay, it's a cheap electric fireplace, but it's got a heater in it, so it keeps the shanty kind of cozy. But why are we in the shanty this late at night? We should be inside with our feet up, enjoying life. We're in the shanty this late at night because chaos has ensued. Let me give you an analogy. There's this sport in the Winter Olympics called snowboard cross, where 6 snowboarders start at the starting line and they all leave together and they race to the finish line down a course with curves and jumps and all kinds of stuff. And inevitably, 1 or 2 of them are 20 or 30 yards behind the other 4 or 5 that are up in front fighting for the lead. And they go around a corner and one of them falls and takes the other 5 out. And the guy 20 yards back tortoises it across the finish line and wins. That reminds me of what's going on with these vaccine mandates and the litigation that's ensuing. Got states running around suing all over the place, suing the federal government all over the place. And the latest one happened tonight, and it came out of a federal district court in Louisiana. Yes, a federal district court. That's a trial court in Louisiana. And the plaintiffs in that case were the states of Louisiana, Montana, Arizona, Alabama, Georgia, Idaho, Indiana, Mississippi, Oklahoma, South Carolina, Utah, West Virginia, Kentucky, and Ohio. And they sued in the federal district court in Louisiana, which is in the Fifth Circuit, and sought a preliminary injunction against the implementation of the Centers for Medicare and Medicaid Services vaccine mandate. And I think I got that right. It's either Medicare and Medicaid or Medicaid and Medicare. I always get them backwards. But that's what they did. And we're talking about that lawsuit because the judge in the federal district court in Louisiana issued a nationwide injunction tonight enjoining the implementation of the CMS vaccine mandate, which went into effect on November 5th and which had a deadline coming up here in December and another in January 4th, and covered certain healthcare workers. And all those healthcare workers needed to be fully vaccinated by January 4th. And remember, in the CMS mandate, unlike the OSHA ETS, no testing. It was a vaccine mandate, unless you had a disability or religious objection. The Medicare, Medicaid, CMS said they had the authority to do this. The 10 states said they didn't. It's a 34-page opinion, which we're not going to get into. Suffice it to say this. The judge issued a preliminary injunction finding that the states were likely to succeed on the merits, and then did the whole 4-prong analysis that we talked about last time that the Fifth Circuit went through to issue a preliminary injunction. And as a matter of fact, they piggybacked a lot off of the arguments that were made in the ETS, even though I don't think they're the same arguments, but he did that. And he said this: in addressing the geographic scope of the preliminary injunction, due to the nationwide scope of the CMS mandate, a nationwide injunction is necessary due to the need for uniformity. Although this court considered limiting the injunction to the 14 plaintiff states, there are unvaccinated healthcare workers in other states who also need protection. Therefore, the scope of this injunction will be nationwide, except for the states of Alaska, Arkansas, Iowa, Kansas, Missouri, New Hampshire, Nebraska, Wyoming, North Dakota, and South Dakota, since these 10 states are already under a preliminary injunction order dated November 29 out of the Eastern District of Missouri. That's right. On the 29th of November, a district court judge in the Eastern District of Missouri issued a preliminary injunction prohibiting the CMS mandate from going into effect in those 10 states, the 10 states I just listed. So now, between this order in Louisiana and that order in Missouri, we have a nationwide preliminary injunction prohibiting CMS from implementing the order. So for those of you that were covered by the CMS mandate, it's halted, just like the ETS is halted. All right. What does that mean? We don't know, because the CMS hasn't asked yet. What we do know is those deadlines that are coming up aren't going to mean anything in the short term, as long as this stay is in place. Now, the court said the stay was going to stay in place until the Fifth Circuit made a decision on it, and ultimately the Supreme Court made a decision on it. Don't fool yourself on all of the things we're going to talk about tonight. Ultimately, these are all going to the Supreme Court of the United States, and the Supreme Court is going to have to make a decision. And the likely outcome is that these stays will stay in place until the Supreme Court makes a decision. Unless one of the courts, the Sixth Circuit or the Fifth Circuit, and you know the Fifth Circuit's not going to do it, they've already indicated that with the ETS, lifts the stay. All right? So, CMS now stayed nationwide. For those of you that are covered by it, nationwide stay. It's a hard stop, right? Until we hear something out of one of these courts. But, like with the ETS that we're going to talk about in a minute, you might still want to get your policy in place in case the stay is lifted. That way you've got your policy in place. Where are we on the ETS? Let's talk about that a minute. As you all know, the Fifth Circuit also issued a nationwide stay. Preliminary injunction and stay, they're not the same, but they're the same for our purposes here. They issued a stay of the ETS, and ultimately all 34 of those cases were transferred to the Sixth Circuit, which happened when the lottery occurred and the clerk of the court reached into a barrel and pulled out a ping pong ball that said the Sixth Circuit on it. There's two things that have happened in the Sixth Circuit that are of interest to you. First of all, on November 23rd, the Biden administration filed a motion with the Sixth Circuit asking it to lift the Fifth Circuit stay and allow the ETS to go into effect. The Sixth Circuit has not acted on that motion yet. The other thing that's happened is that the other side filed a motion with the Sixth Circuit asking the court to hear it en banc. En banc means all the judges hear it instead of a panel of 3 judges. Now, the reason they did that is because the Sixth Circuit is predominantly filled with conservative Republican-appointed judges, way more Republican-appointed judges than democratically appointed judges. So these people believe that filed this motion, if the whole court hears it, it's more likely that the stay will stay, right? You see what I did there? The stay will stay. That's pretty good, huh? Not bad for 9:30 at night on a Tuesday. So they want the whole court to hear it instead of risking a random panel that might have 2 more liberal judges on it that would lift the stay. I think you can overrate that stuff, and I've said that before, but that's where we are. Okay, so the ETS is also state. Now, we've got a third one out there that we haven't talked about yet. What about the federal contractor mandate? Well, there's also been litigation on that. And by the way, if you can see this stuff in my glasses, I'm sorry, they've got that blue screen on them and it reflects the screens, and there's nothing I can do about it when we're recording at night. My lighting is not that sophisticated. I need to get a pro, I guess, to do this stuff for me instead of the amateur job that I'm doing. But back to Executive Order 14042, where are we on that? That's the federal contractor and subcontractor mandate. And again, that is a mandate. It's a hard mandate. No testing option there, right? Well, there's also been litigation on that. Today, another district court judge in Kentucky issued a stay of that order, but that stay only applies in Ohio, Kentucky, and Tennessee. Why Ohio, Kentucky, and Tennessee? Because Ohio, Kentucky, and Tennessee were the plaintiffs in that case. They filed the lawsuit. You notice that that's all in the Sixth Circuit, which is where Michigan is. Is it stayed in Michigan too? The answer is no, because Michigan wasn't a plaintiff in that lawsuit, and we have not sued we haven't joined any of these lawsuits suing to get any of these mandates overturned as a state. Agree with that, disagree with that. It's a fact. It's what's happening. So that injunction only applies in Ohio, Kentucky, and Tennessee. Now, whether or not a district court can issue a nationwide injunction like the guy, we're not going to get into that. It's sufficient that he did, and we'll have to wait to see what CMS has to say about this and what they're going to do to fight it and how they're going to fight it. And I assume they're going to appeal directly to the Fifth Circuit, which is probably not going to do them one bit of good. We already know how the Fifth Circuit, at least one panel of the Fifth Circuit, feels about this, because they put the stay in place for the ETS. All right, so, but with the federal contractor mandate, we do have some lightening up by the administration. So we've got dates coming up in that for people to start getting shots and being fully vaccinated. And the federal government, the White House has said, look, those dates aren't cliffs. If you can show that you're working in good faith toward getting your people vaccinated, contracting officers are going to work with federal contractors to try to get them in compliance before they take disciplinary action against them. So that's also a little kind of lifting of the pressure, if you will, under those ETSs. But here's the bottom line. And I said ETSs, I meant executive order. Here's the bottom line. Okay, for the CMS mandate, we now have nationwide injunction stop, right? It's a hard stop. So you're not going to have to fire people who aren't vaccinated on January 4th unless this thing is lifted. Until the court says this is lifted, that order isn't going to go into effect. But you might want to get your policy done and have it ready to put in place in the event that the stay is lifted. On the ETS, also nationwide injunction. There's a stop there. But remember, we're coming up on a deadline for the ETS. And we have been recommending all along that you continue down this path. What you have to have done by December 6th, I think it is, or 5th, is you've got to have a policy. You've got to know the vaccination status of your employees. You have to have a record of the vaccination status of your employees. And you have to have a roster. Now, you could do any of those things or all of those things, whether the ETS ever goes into effect or not. It's legal for you to do that, to get that information from your employees. What we've been recommending and what I'm continuing to recommend for those of you that might be covered by the ETS is that you do those things and get them in place. It's not going to hurt. It's not illegal. You can do it. You can find those things out. And if the stay is lifted by the Sixth Circuit, then you're in compliance and you're ready to go. So I would suggest you continue down that road. For those of you that are federal contractors here in Michigan, it's still full steam ahead. You've got to get in compliance with that federal contractor mandate. So with all of that being said, if you have any questions at all, if you need anything, if you want to talk through this, give one of us a call. We'll be happy to talk to you. That's it for me. I'll see you in a couple of weeks. Have a good night.